This might be a good time to point out, too, that people in association do not have a degree in HOA. These are volunteers. And so I would imagine this might happen quite often.
I think the fundamental point that you're raising is these are volunteers.
Correct.
And there's no credential check, right? And you have some very intelligent people on boards. I've met them, I've deposed them. And, even very intelligent individuals, they still sometimes operate out of self-bias, self-interest, and that becomes very problematic, irrespective of intelligence. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. All right, Luke Carlson of L.S. Carlson Law, welcome back to the show. We're thrilled that you're watching. I also have to my right, Marty.
Hello.
Marty, welcome.
Thanks.
And Jenny, welcome back.
Hi.
So I'm a lawyer of L.S. Carlson Law, and as we've been doing in this series, we're really identifying areas of concerns or things that are creating absolute nightmares for homeowners. So last week we did failure to repair, which is a huge topic. Yeah. I thought that was very helpful. I think it was
interesting.
It comes up over and over and over again. Now we have another topic, which I think causes an equal amount of nightmare for owners, which is selective enforcement.
Yeah.
So we are going to dive into that today, and hopefully the viewers will get some good insight into this nightmare, or this variation of yet another nightmare of association.
This ongoing
nightmares, yes.
All right, what is selective enforcement?
So selective enforcement is really one of those areas where we see it materialize in a number of different ways. So you're a homeowner and you're living your life, you're minding your business, and all of a sudden you're getting notices. Maybe it's because they don't like your shrubs, or they don't like the color of your house.
Or your wall is peeling.
Yeah.
That is very specific.
That was very specific.
Do you care to share?
We'll go into that another time.
Yeah, we'll put
another episode.
Yeah, that's a good one. But then you look at your neighbors and you see that they have the same outstanding issue. Their wall is peeling, or their shrubs are all out of whack. And you talk to the neighbor and they say, yeah, we're not getting any violation notices. And you come to realize that you're the only person being targeted in that sense.
Yeah.
So that's a form of selective enforcement that we see over and over again in California. Is very common, unfortunately. Sure. So that is selective enforcement, where you're getting targeted to the exclusion of others. Your other neighbors, the other owners aren't getting ridiculed, or they're not under the microscope, but you find yourself under that microscope.
Yeah.
Or you have a target on your back.
Yeah.
So that is selective enforcement in a nutshell. All right, what do we have next?
So what are some of the, legal implications of selective enforcement? I think we did a decent job on saying, okay, it's really lack of consistency.
Yeah.
Or they're being targeted specifically. I guess those are the two main areas of selective enforcement.
Yeah. So when you're looking at selective enforcement, it gets interesting because one, there's often a motive behind it, and that motive is someone on the board, or the board in general, doesn't like you. They just you go back to our personality types, right? You have a tyrant, a meddler. Typically, it's not an incompetent. That's rare. It's most likely vindictive in nature. That's what we see. So the problem with it, though, from a legal perspective, is several things, right? So first and foremost, in California, you have the governing documents. Governing documents are very clear, most of them, that they say it's an equal application of the rules and regulations. Yeah. So when you don't have that equal application, meaning one person is just targeted, no one else is being targeted, there's almost that immediate breach of the CC&Rs, because there's that unequal application of those rules and regulations.
And that's in the Davis-Sterling Act, that it has to be equal in application.
Davis-Sterling Act discusses it, but you'll often find actually in the CC&Rs themselves, there's a provision that says that these rules and regulations must be applied equally to all owners.
So an example could be 3 people have a peeling wall, and only one person gets a notice of violation.
Exactly. And I guess the other caveat to it as well is that peeling wall is open and obvious.
Correct. But you may share it with a neighbor who also is peeling.
What's that?
You may share that wall with a neighbor, and their wall is also peeling.
Well, yeah, if it's like a shared wall, maybe.
Yeah.
But yeah, it's something that's sort of open and obvious in the community that the board should know about it if they just walk around the community. And for whatever reason, you're targeted. So that could become that breach of governing documents. The other thing you got to look at in California too is, and we've discussed this before on the show, the board owes owners a fiduciary obligation. It's a fiduciary relationship, which really is just a heightened standard of care. It's a heightened, elevated relationship or duty that the board owes the homeowner. So
in most situations, is this just they kind of remove the thought of, okay, it's a fiduciary obligation, and they're still in like neighbor mode, and just it irritates them, and they have a little bit of power. So it just sounds like it's more than likely tyrannical behavior.
Typically tyrannical, or maybe a meddler. Maybe a meddler has fixated on you, and for whatever reason, they like to just kind of push your buttons, and they do it through enforcement action. They call you to a hearing.
Yeah.
They send you fines. They send you violation notices. Sometimes they'll actually weaponize the lawyer that works for the association. So
that seems very aggressive.
How would they do that?
Well, you have an association. Association has in-house counsel or corporate counsel.
Yeah.
Now, again, there's some great attorneys that represent HOAs. I know them, and they do a great job. They're even-keeled. They help manage. They make sure that the associations comply with the CC&Rs, the Davis-Sterling Act, and they really perform at a wonderful, or they provide a huge asset to the community, a good HOA attorney. But sometimes these association attorneys are hired guns. So if the meddler goes to that attorney and says, hey, hit Susie Q with another violation notice.
Just because I don't like her.
Maybe they don't even say that, but the association attorney will just do it without that sort of due diligence or extra care.
They're getting their money. They're getting their hourly. They're like, okay.
Yeah, they're getting their hourly, or they've consumed the Kool-Aid, or they're best friends with the tyrant. Right,
Yes.
and that's the weaponization of an attorney. I guess it's a dramatic way of saying it, but in effect, that's what's happening. So that could be, so you're looking at it from a legal perspective. You're looking at that breach of fiduciary. You're looking at the breach of governing documents, potential violations of the Davis-Sterling Act in California. And that's how legally we start articulating this form of malfeasance. And again, I think the purpose of the show in a large sense is to educate viewers who are experiencing this so that when they go to the board or when they have to go to a lawyer, they have an elevated way to articulate what's happening.
And to also know the proper steps to take.
Yeah, and we'll get to that. But just, elevating your vocabulary is a step in the right direction.
Well, you start using this vocabulary around, people are
They're going to pay attention.
Well, they're buzzwords.
The ears are going to go,
Yes. You mentioned the Davis-Sterling Act.
Yeah, they're not messing around anymore.
Right. Now you're a sophisticated owner coming to the table, maybe with the board, and instead of saying, well, that's just rude, you guys are obnoxious, that's one way of articulating it. But a better way of saying it is saying, hey, from my perspective, this is a potential breach of fiduciary. This looks like it's running afoul to the Davis-Sterling Act. Now your vocabulary is elevated and your language carries more meaning.
Sure.
And it
Absolutely.
typically gets more traction or more attention.
This is just a good life lesson in general. Become knowledgeable, right?
True. Yeah. And, unfortunately, you're an owner in that situation. You're very emotional, rightfully so.
Yes, but you have to educate yourself first.
But if you can put that emotion aside the best that you can, contain it, and look at it more clinically of, hey, what is happening to me legally?
Right.
That is where you get traction.
Well, it has a lot more teeth.
It does.
Point.
Yeah.
And if you're
your
familiar
anger.
with your CC&Rs.
Correct, which I encourage everyone to be anyway.
Yeah, absolutely.
Which is in the steps.
Which is in our steps.
Which, good tease.
Good tease.
So let's go through some of the legal implications that we just kind of talked to. We briefly touched upon breach of fiduciary, but there's some other areas within the law that they could be breaking, which we kind of have here, such as discrimination claims, violation of governing documents, equitable relief, et cetera, et cetera.
Well, discrimination claims get interesting. Discrimination law is its own practice area.
Sure.
Right. And in the U.S. there are certain protected classes.
Yeah.
So if you're being discriminated based upon a protected class, that becomes a whole different ball of wax. It falls outside of my pay grade. We don't, when a case like that comes in, we can of course handle the selective enforcement. But when it looks like discrimination based upon race, religion,
whatever.
what have you, then you really need a specialist to come in and look at how to handle that, because those claims are handled completely differently than how we prosecute claims.
But in a sense, that is part of the area of the law that they could be breaking, but it's something that
Correct.
you guys typically don't.
Correct. We'll bring in a specialist for that, or someone who is very knowledgeable.
Yeah.
Makes
We
sense.
stay in our lane.
Yeah. Understood. And we've talked about violation of governing documents. That's usually the one that they're ticking the box when I've noticed in most of these situations. The one thing that they're doing is the HOA is not following the governing documents, and
Right.
that's usually the one that says, "Oh, it's glaring. It's right here."
Right.
Yeah.
Yep.
So-
Correct.
Talk to me a little bit about equitable relief. I saw this that came up. I'm like, what is the definition of equitable relief?
So when you're looking at different forms of relief, and really you're looking at a court. What can a court do? And often most people think of the court as monetary relief. They're looking for some payout, right? I've been damaged. I've lost the use of my property. My property's been damaged. I
Now
want
I wanna pay
reimbursement
out.
for that. So equitable relief is a little bit different. It's actually the court coming in and affecting some sort of change that's non-monetary in nature. Often, right? You're looking for, it's an equitable play. And so there's, taking out of just the term equitable relief, let's just talk about relief in general, right? So you have monetary relief, but you also have the court ordering the association to do or not to do something. So, a good example is, let's say, there is a common area element that needs to be maintained. The HOA is not maintaining it. You're actually looking for the court to say and order the HOA to do something about the common area. You're forcing them to do something. It's a form of specific performance. You're actually telling them, hey, I need this to be corrected. That's not monetary, but it's the court ordering some sort of conduct,
That makes sense.
or maybe
Yeah.
stopping some sort of conduct, right?
That makes sense.
If you look at a cease and desist letter, right, that's a form of telling an association to stop doing something, stop behaving in some sort of conduct.
Sure.
That is in and of itself a form of relief, which isn't necessarily monetary.
And I would assume selective enforcement is, in more cases than not, that's what you're looking for.
Or you're typically looking to cease and put a halt to some sort of misconduct.
Sure.
Yeah.
That is typically the end game.
And the only, in most situations, when it becomes a monetary situations, usually when they rack up fees or fines.
Attorney's fees, and it's a bit nuanced. I don't want to go in
Sure.
too granular
Yeah.
on it, but overall, you're looking for some sort of curbing or putting a halt to malfeasance.
Yeah.
That's targeting you.
Yeah.
Right. That's the end game.
Sure. So talk to me about loss of HOA credibility and authority.
Okay. So when you have a board engaged in this sort of unequal application, right, the issue it creates, I think, more globally, or at least in the community, is it really discredits the HOA, the association, right? Because now you have a board who's, through evidence we can show, is targeting one homeowner, right? And a well-functioning association, again, it's equal application, right? They can target people so long as they're targeting everyone who's in violation.
Sure.
There's nothing wrong with that, but it's when it's that one person with the one violation, and they decided to say, you know what, I'm going after that person, to the exclusion of everyone else. That becomes very problematic. And then in the community, if the community gets wind of this, I think it starts to really undermine the credibility of an association.
This might be a good time to point out, too, that people in association do not have a degree in HOA. These are volunteers. And so I would imagine that this might happen quite often.
I think the fundamental point that you're raising is these are volunteers
Correct.
and there's no credential check, right? And you have some very intelligent people on boards. I've met them, I've deposed them, and even very intelligent individuals, they still sometimes operate out of self-bias, self-interest, and that becomes very problematic, irrespective of intelligence.
100%.
So you have PhDs who are doing this, and one would think that with that level of education, they would say, okay, let me look at the CC&Rs, let me look at the Davis-Sterling Act, let me understand what my responsibilities are, and execute within those parameters.
Yeah.
And then they don't. So education isn't always an indicator of how they're going to perform. Because on the other side of it, I have individuals who don't have that level of education, nothing near that, but they're on the board, they're altruistic, and they do great work for an association.
Sure.
That's not what hits my desk, though.
You get the other side.
No, I get the dumpster fires, always. So loss of credibility and authority.
And that can just spiral, because when the homeowners think that my HOA does nothing, or they could just start taking advantage of it at that point, and then you've lost all credibility, and then it becomes San Francisco CVS's.
There you go. It's a very hot topic right now. Yes. Yeah.
May not keep
Lawlessness. Yeah.
I kind of liked it.
All right. All right. Resolution. This is a good topic. So yeah, going back to practical advice, you're a homeowner, you perceive what's happening to you as targeting, selective enforcement. Again, evidence, document everything. I think that's so critical. It's one thing to experience it and testify and say, hey, this is what's happening. It's another thing, though, to have emails.
Sure.
Verifying, where you send emails to the association saying, hey, this is what's happening to me.
Yeah.
And as a non-lawyer, I think that's the best reminder, is just to have everything in a file. Like you said, document, save everything. If you have any question, make sure you ask it. Make sure you have a paper trail.
Well, pictures. Just document beyond sending an email. I would assume if your neighbor has the same issue with the wall, that take pictures of that and mark it what the date is, and be able to show some sort of documentation.
Yeah, or even a more elevated approach. It's a little bit weird, I guess, politically with other neighbors, but assuming everyone sees it and says, hey, you're being targeted. I don't know why. And you send an email to Bill, your neighbor Bill, say, hey, Bill, so nice speaking with you again. This is just to confirm that you haven't received any sort of adverse action from the board, right? Another area, too, is in the architectural control committee, where there's sometimes unequal application there, meaning let's say you want to put up a gazebo or build a pool, and your application gets denied over and over and over again, but everyone else has a pool or everyone else has a gazebo.
Right.
They just don't like you for some reason. That's another area where selective enforcement arises, right?
Sure.
And going back to the documentation, that's an email to Bill, your neighbor Bill again, saying, hey, Bill, just to confirm, you got your pool approved seamlessly?
Yeah.
And you also live on a hill, and you also.
Right. No, exactly. So document everything. Knowing your governing documents, that's, owning in an association 101. Understand the documents. And yes, they're boring.
Understand documents, educate yourself.
Education.
So step one, collect the evidence.
Correct.
And then
Document everything.
Document everything. And then step two is review your CC&Rs, your bylaws.
Understand them inside and out. Yeah.
Okay. Then what's step three?
So, to the extent that you can make a request, if it's necessary on the board, you're entitled as an owner to certain documentation. So I would encourage that, a document
I have one
request.
question.
Yeah.
So if you were wanting to put in a pool, they rejected yours, and then the neighbor was able to put in a pool, could you request the neighbor's documentation?
It depends.
Okay.
It's sort of community by community. And some will just turn it over. So there's some associations that run at a very transparent clip. More transparent than they actually need to be, but they're not hiding anything.
Sure.
So they're okay with disclosing certain information.
So, but if there's a tyrant on the board,
You're not getting that information. even if legally you're entitled to information, they're going to hold it back.
Are you? Does California law, specify that you are entitled to some sort of documentation?
Yeah, it's under 5200 of the Civil Code. Okay. So if you want to jump into that, read it, the code section. You can start to sort of cherry pick which documents you're entitled to, and that can become a very powerful tool. But often, with the selective enforcement, there are situations where, yes, documents from the association are very helpful, but more often than not, the documents that you sort of gather independently can be very powerful.
Sure.
So I don't want a homeowner to think that they have to go under this fishing expedition just to prove up their case.
Yeah.
Right. So, it's case by case, but
to the extent, it would be nice to know, hey, did Bob down the street get fines for this as well?
Yeah, and sometimes the best way of doing it is just asking Bob.
Yeah.
Yeah.
Right?
Yeah.
If you're a natural meddler, you do like to know what's happening.
That's a meddler homeowner.
Homeowner, yes.
Yeah.
Not a board member.
Yeah.
But
Keep
yeah.
your meddler cap on
Yes.
as you're trying to solve this.
Yeah, but at some point you're going to sit down and say, you know what, I have a good amount of evidence. You might not have everything, but maybe you're 80% there. At that point, again, I'm always of the opinion that if you can work it out with the association without a lawyer, that's a win.
Which is the next step, is just informal.
Yeah.
Contacting them and try to solve this.
So yeah, California has a great opportunity to do so, and we've discussed it over and over and over again. But I think it's worth, harping on. It's really the informal dispute resolution process. Demanding IDR with the board, again, I would argue that there's real no magic language to it.
Yeah.
You said even using that verbiage
But the verbiage could help.
will be
Yeah.
very helpful.
I'm making a request for informal dispute resolution. Here's my issue.
Yeah.
Give me some days and times that work for you.
Yeah.
And again, in the ideal situation, the board sits down with you and says, hey, you're right. I don't know what's happening here, and it's rectified, right? When you're dealing with a bad board, though, the IDR process can be an absolute waste of time. It can be very frustrating, especially if you're sitting with 3 or 4 or 5 board members and they're all telling you to go kick rocks.
Would you, even if you perceive the board to be tyrannical or
Just
and
difficult
pretty
nature.
and difficult, would you still go through the steps of attempting IDR, or would you?
Yeah, like would you do it for documentation purposes?
Or would you split that all together? Just say, forget it.
We have a mug at this firm that says it depends. And lawyers
And everybody wants
lawyers say that all the time. And the reason they say that, though, is because it really does depend.
Sure.
Now, I'll tell you why. Let's say you have a tyrannical board and you know unequivocally that they're going to tell you to go kick rocks. You know it. You know if you show up at that board, it's going to be a shouting match and the tyrant's going to yell at you.
But do you do it anyways just for documentation?
Well, that was what I was getting at.
Oh,
Yeah.
before I jumped in.
Good
No,
job.
but you nailed it, right? You're almost going there. You're going in good faith.
Yeah.
You have a horrible encounter, but now you have a horrible encounter to add to your file.
Right.
And you can even send a follow-up email.
Beautiful paper trail.
Dear tyrant, thank you so much for that horrible IDR session where you shut me down and you called me an idiot. Right? I mean, it's sort of backing that, what happened, documenting it, and now you have one more thing to show, hey, look at the bad faith.
Are they required to keep like minutes or anything like, or record these?
Probably it depends.
Well, no. There is a requirement under certain meetings. It depends on how they're framed. Typically with IDR though, there's no minutes.
Okay.
I mean,
Just so you have documentation of
some boards will take notes, right, and that becomes part of a file. But I would say assume not. Put the onus on you.
Okay.
You always assume you have the burden to document, because if you're in the situation in the first hand, don't assume that they're well functioning where they're taking notes.
Yeah. Would you just pull out your phone? Okay, I'm just gonna record this, and then the board's gonna say, yeah, no way.
Well,
Yeah.
if you ask them and they agree, you can do that, but you certainly should not record without anyone knowing.
Yeah, for sure.
That's problematic
Yeah,
on a whole
yeah.
different level.
Yeah.
But yeah, if you get everyone's consent, that's not a bad idea. They're
Just for
They're gonna
note-taking
say
purposes.
most likely they're going to say no.
Yeah.
Give it a shot, sure.
Everything's worth a try.
But yeah, the attempted IDR, even if you think it's going to fail, may not be a bad idea. Now, you could be of the opinion, though, you have so much evidence, why subject yourself to that? You know it's going to fail. You already have good evidence that it's selective enforcement. You already feel very confident in what you have. Maybe you don't waste your time and energy on that.
Yeah.
And you just go to the next step, more of an elevated, aggressive approach to the board.
Which is time to bring you
Well,
on.
that's when you hire a lawyer, right? But you typically don't start with just hiring a lawyer, right?
Yeah.
You typically meet with a lawyer. Some lawyers give free consultations. Some charge by the hour. It just depends on the lawyer and the business model. But you get this in front of a lawyer. You bring all the documentation, and I think the better organized you are, it's going to make the lawyer's life easier accessing the file.
yeah.
yeah.
You showing up with nothing and saying, "Hey, this board is out of control. They're coming after me," versus, "Hey, I believe this is selective enforcement. Here are my CC&Rs. Here's the photographs. Here's emails to the board regarding the outcome of the IDR."
So wait,
Yeah.
hold on. A dream client that was coming to you, you would like them to, as much as possible, take the emotion out of it, have a well-documented.
Yes.
Yes.
Yes. And
Well
I never,
issue.
when clients meet with us, though, I assume there's going to be a good amount of emotion.
Yeah.
Rightfully so.
Yeah,
Unless
it's their home.
you're a robot, like they're under such a bad situation where it's almost, and I tell the attorneys here, to some extent it's like working in an ER, an emergency room. When people come in, they're in bad shape because of what the board has done. And so
And probably emotionally drained.
emotionally drained, frustrated.
I can't imagine this being like, oh, it just started last week. This is probably
It's-
sometimes years.
Years of this.
Yeah.
And you also have to understand as the lawyer is that, you almost become a necessary evil in this equation.
Sure.
They don't necessarily want to meet with you. And I get
Right.
it, right?
Yeah.
You don't want to show up in the ER and be in front of a doctor operating on your injury, right?
Yeah.
But your bone is sticking out of your leg, right?
Yeah.
I know that's graphic. But, the point is that doctor is going to help. The doctor has to be there. It's a necessary evil given the circumstances.
Yeah.
So empathy is tremendously important. And yes, I mean, obviously a perfectly clinical, consult where someone comes in like a robot and says, this is it, and we can look at it at arm's length, yeah, that's going to be really efficient, and we're just going to knock it out of the park within like 20 minutes.
Right.
But you got to calibrate the emotion because it's relevant. And the emotion is also relevant, though, when you're getting the story out. Because eventually you're going to get this in front of, let's say, a mediator, a retired judge, or if it goes as far as a judge or jury, that emotional side, in my mind and my assessment, is absolutely critical because it's the human element to this. This isn't a arm's length business transaction where, two big companies, spent some money and it went south. And it's a bunch of C-suite executives who are like, we want our money back.
Yeah, or partners splitting up.
So yeah, there is, these are highly emotional cases, but for better or worse, I think that information is important.
Yeah.
And to get that story out is also important, in addition to all the legal aspects of the case.
How much easier is it for you when a client comes out with just great documentation?
Oh, it's seamless.
Right?
Yeah, and I think it just makes the representation much more efficient. And there's a huge cost saving in it as well.
I bet.
I've had clients who come in with a binder that's organized, and it cuts down on how much work we have to put into the case, just because it's all there, it's laid out.
That makes sense.
Versus,
they have a copy of their CC&Rs, they're well versed in them.
As opposed to us trying to find all the information and cobble it together, which we can do. We got very, very good at that, but it takes more time.
Yeah.
I've had situations where people have shown up with banker boxes of information, disorganized. And that's fine. We'll jump in. We'll get through it, but it just takes more time.
It could take hours and hours to go through that.
And I get it. Some people just don't want to deal with it.
Yeah.
They're like, listen, here's all my evidence. Just you deal with this nightmare. And then
me with taxes.
It's similar. Most people with taxes, right?
Right.
You just don't wanna,
you can dig through my basics.
right. You give it to your CPA and you say, okay, figure it out. Get out the abacus. So yeah, I think
you might need a new CPA. Okay, so just to recap this: document the issue. Review your CC&Rs, request records if you can.
Yes.
Try to take this from an informal approach. Just approach them in some way or another. Then IDR, and if that all fails,
talk to a lawyer.
Time to get an attorney.
Talk to a lawyer regarding next steps.
Perfect.
That's it.
All right, Jenny, favorite part.
This is the highlight.
My favorite part.
Okay. The Reddit rapid fire. Here we go.
It's kind of like a bar exam on air.
All right. I receive friendly reminders, and I have received one violation. I've asked for pictures, but they say they don't take pictures. So I don't understand how they are so sure. My next door neighbor is the president of the HOA, and I feel like he nitpicks my home. A letter regarding weeds in flower beds. I had just remulched my entire yard out front, and I was floored. So I asked for pics. They couldn't provide any and said they don't take pics. Say that again. I got an actual violation for my eaves not being power washed. No pic to provide. I just think it's him selecting to enforce just because I got the unlucky lot next to him, and he hates that we are young and have kids and dogs.
Okay.
So President lives next door, and it seems to be
targeting
happy
families with dogs.
Yeah.
What's funny about this one is I see this one come up a lot.
Really?
Yeah, a lot of sometimes when it is a scenario like this, maybe a variation of this, one of the first questions I asked is, "Who's your neighbor? Are they on the board?" Because maybe 70% of the time, someone's on the board. So
and they're going to see your stuff
they have to
regularly
look at it all day long out their bathroom
right,
window.
and they care, and that's almost this. Now you're in a situation of almost like a preferential treatment. Like the board is
the inverse.
Anti.
Yeah, no, because what they're doing is they're leveraging their position on the board to beautify their perimeter, what's around their house. They don't care about anyone else, but they care about left and to the right. That's the issue, and. On this scenario, for example, what this individual might want to do is go around the neighborhood, see what's happening at other homes.
Yeah, see if their eaves have been power washed.
Correct. And listen, if they're above, let's say the threshold is here for the beautification or the condition of the neighborhood.
Yeah.
This is like the average, and they're like even here or above.
Yeah.
They have a pretty good argument that this is selective enforcement.
Yeah.
So yeah, this is one that I think it comes down to the evidence. Now, if you look at all these other homes that are also in the same state of, let's say, disrepair, I don't have any pictures, obviously. But if it is sort of bad and other neighbors, their homes are equally bad, but they're also getting violation notices, then it's a different complexion.
Sure.
Entirely. It's a different analysis.
Okay.
But yeah, if this person can show, hey, no one else is getting
Like
violation
my
notices.
eaves are 50% power wash, but if you look at all these other examples of these guys,
Right.
So at that point, you're going to do a little bit of door knocking.
Door knocking.
Hey,
picture taking.
Did you get any violations for
Or,
your eaves?
let's say you're uncomfortable going door to door and saying, hey, I really think your eaves are a little bit out of whack. Mine are too. Are you getting violation notices? Let's say you don't like that idea.
Yeah.
What you could always do too is you could force an IDR and put the board to task and saying, hey, I have this situation. I've noticed a bunch of other homes that are also out of whack. And you can simply ask the board, are these other neighbors getting violation notices? Because I think it's only me.
Here's my pictures.
Yeah.
Right. I take pictures.
Yeah.
So that would be an interesting way of cutting that and putting the board on their heels. Because if the board's like, well, we're not finding anyone else.
Okay, this sounds really silly, but does in many situations do HOAs have people walk around and just
My gosh, yes, they do.
That also sounds very
really?
personal.
Yes.
Do tell.
No, I've seen it in our neighborhood, but my mom's neighborhood. She lives in a condominium complex in Mission Viejo, and there's actually a gal with a clipboard. And you can see her like every other time I go
Is she
there.
actually on the board?
100%.
So that's the question. Do they do this like regularly? Just
Sometimes.
do an inspection.
It depends.
It depends on the association. Some are very aggressive. Some have people going in golf carts looking at homes, making sure that
we talked about
drones, golf
Yes.
carts, segways. What are those things that the mall
I'm going to
cops
get a
use?
picture of
Segways.
gal
Segways.
with a clipboard.
So yeah, no, and that's not necessarily a bad thing.
No, it could
per
be
se.
a great thing.
No, because that
Yeah.
could
I mean,
solve
if-
selective enforcement
Yeah.
in a lot of situations.
Correct. And typically when this situation arises, and assuming it is actually selective enforcement, someone's not on a Segway with a clipboard. It's just that board president going outside, getting their newspaper and saying, hey, you know what? I don't like that. I'm going to bring it to the board's attention. But not caring about any other aspects of the community. That becomes selective enforcement. And that becomes problematic.
Got it.
So that was a good one, though. It'd be interesting to dive into that one and kind of see like what the other homes look like. And but yeah, there's some plays there for sure.
All right. What's our next episode?
All right. We got another one.
There's
this
a
is
couple more.
This is a fun one. Neighbor disputes.
This is an interesting one for me because I always try to figure out how
Do you have a
disputes.
juicy
How does
neighbor?
it relate to HOA?
Neighbor disputes. This one will be a little bit more technical, legally speaking, in terms of how to enforce against a neighbor and sort of what the association's liability, if any, is in sort of that dynamic, right? And you're kind of assuming you have one neighbor who's doing something horrible in violations of the CC&Rs, the association is taking no action, and now you are living a nightmare because of a failure to enforce. So I won't get too much into it, but yeah, that'll be a good one. Yeah.
Those are always fun as usual.
Yeah. Well,
right.
Marty, thank you again for being on the show.
Thanks for having me.
Excellent questions. And Jenny, thank you. Wonderful questions, as always. And guys, thank you so much for watching. And if you love the show, please subscribe. I've been told to tell people that.
Subscribe.
Press the button.
By our
Press the button.
12-year-old daughter.
Yes. Give us a thumbs up. All right. Thank you.